Hello, my name is Shea Doyle, and my presentation is on the criminal competency of exercising the right to remain silent. First slide, what is the right to remain silent? Exercising the right to remain silent is often viewed as the right to avoid self-incrimination. However, in some circumstances, choosing to remain silent in some situations may seem as incriminating evidence. The first thing a person hears when the Miranda rights are being read to them is that they have the right to remain silent and that anything they say can and will be used against them in a court of law. Having the competence to remain silent plays a large role in evaluating the circumstances of obtaining confessions. Decisional competence. The competence to exercise the right to remain silent is a type of decisional competence. This means that in certain criminal justice situations, a defendant must possess the competence to make a particular decision. In this circumstance, that decision is being able to choose between speaking or remaining silent about the crime in question. In situations where a defendant is unable to or lacks the capacity to make this decision, the state will invoke its parens patriae authority, that is also known as the state as parent. So you're the state's taken over as your parent for you and making decisions for you. So we need to learn about the law of confessions. In cases where the competence of a defendant is at question during the time of confession, courts will have a psychological evaluation performed. And understanding this law of confessions is necessary when performing these evaluations. There are many competing considerations. For example, while the prosecution relies on obtaining a confession from a guilty defendant, sometimes confessions may be obtained through the use of unfair interrogation tactics, which may lead to a mistrial. These unfair interrogation tactics were somewhat brought to a halt after the Brown v. Mississippi case of 1936, in which 3 African Americans signed confessions only after experiencing physical torture, hanging, and beating by the interrogating police officers. After 3 decades of this continuous problem, the court decided that Miranda v. Arizona case of 1966 would be used as grounds for excluding confessions. This case relied on the Fifth Amendment's privilege against self-incrimination. It's continued. In most circumstances, when the Miranda rights are not delivered to suspects, anything they say is usually inadmissible in court. If the Miranda rights are delivered and the suspect knowingly, intelligently, and voluntarily waives these rights, anything they may say will be admissible in court. If at any time during an interrogation process the suspect decides to remain silent or seek counsel, the interrogation must immediately cease in any manner and at any stage in the process. Some confessions that may seem inadmissible but are actually admitted by the courts are ones given by suspects who thought they were confessing to another inmate when it was actually an undercover officer, believed only written statements were admissible, so they gave an oral confession, were led to believe they were being questioned about a different crime, and/or were not told their attorneys were trying to reach them during an interrogation. These police actions may seem fraudulent, but they do not fall under the scope of compulsion, which is banned by the Fifth Amendment, or coercion, which is not allowed by the Due Process Clause. Gauging voluntariness is dependent on considering factors such as impairment, intellectual disabilities, and mental illness. However, just because these factors may exist in a suspect does not mean that they are unable to waive their right to remain silent. The basis of obtaining a sound confession that is admissible in court is that the suspect understands their rights at the time of questioning, even if there is evidence of impairment, and as long as police did not take advantage of the impairment. Some evaluation issues. Before going to trial, the admissibility of a confession is considered in order to determine its reliability and to make sure no unconstitutional interference was made by police. If the confession is called into question, there will be a suppression hearing, and at this point, a psychological examination will take place in order to determine 2 things: person-centered factors and situational factors. Person-centered factors can include intellectual functioning, suggestibility, and oral reading comprehension. Situational factors examined could include intoxication if the suspect was impaired at the time, how the defendant was informed of their rights, how the police or officers decided to make them aware of them, either by reading their Miranda rights or in another way. Behavior of the officers, just their overall demeanor, and the general nature of the interrogation process, where it was held, what time it was held, for how long it was held, things like that. Mental health professionals can be of help to courts to determine admissibility and weight of confessions in 3 ways. They can offer testimony to the legal decision makers on whether the defendant's waiver of rights was both knowing and intelligent, provide assessment factors relevant to determining if the confession was voluntary, and offer insight about the types of tactics that could result in a false confession. Knowing and intelligent inquiry. There have been studies done to determine what % of the population actually understands their rights fully, specifically their Miranda rights. It has been found that at least a middle school reading capability is needed to understand these rights. Previous court experience does not mean these rights are understood, so even if they're a seasoned criminal, they've been to court a bunch of times, it doesn't mean that they understand their rights. And juveniles and people with intellectual disabilities are even more likely to be confused about Miranda warnings. An individual must knowingly and intelligently waive or exercise their rights. Voluntary inquiry. To voluntarily waive the right to remain silent is trickier than the knowing intelligent inquiry. For example, if a suspect is known to be easily suggestible, an involuntary confession could be given. This could also happen if the suspect does not do well with the 40 figures. They could be saying what they think the person in charge wants to hear to appease them. Another instance could be that if a confession was given, the suspect was under the influence of drugs or alcohol. Situations such as these need to be handled on a case-by-case basis, where past history, police transcripts, and eyewitness reports must be taken into consideration. False confession research. A false confession does not automatically render it admissible. There usually needs to also be the possibility that the confession was not voluntary and that coercion must have taken place. Studies show that there are 2 ways a false confession coerced by police can occur, and that is through the use of maximization and minimization. You're good to walk. Maximization techniques include fabricating or bluffing about having evidence and insinuating that a failure to confess will make matters worse for them. That could, let's see, an example of that could be saying, if you don't confess now, if you don't make a plea deal to confess or something like that, like you could get the death sentence, and if you confess now, if you plead guilty, to us, then, that could be taken off the table, Minimization techniques include pretending to want to help the suspect or offering rational excuses for the crime, like saying that they understand why they did it or something like that.
You took 2 minutes.
Okay, and then this video I have included, let's see, it says that it is restricted, so I will go ahead and get that fixed. It is just a video documenting the right to remain silent, the Miranda v. Arizona Supreme Court case. Let's see, it determined that prior to obtaining a confession, a suspect must be made aware of their 5th Amendment right to remain silent and avoid self-incrimination, as well as their 6th Amendment right to an attorney. Some references. And the discussion question. After reviewing the PowerPoint presentation, please answer this discussion question. What is voluntary inquiry and how does it more complex than knowing and intelligent inquiry? Also, why might a suspect give a false confession? Specifically, what circumstances may lead to one? And that's all. Thanks.